So let's start with the Gina complaint. Now, we're going to go through this procedurally and kind of read through this. It is not too long. It's 10 pages. So we're just going to read through the whole thing because I like to give you guys the original. I like to give it to you raw. This is fresh off the presses. This was literally recorded at the court on 10/15. It just went public. It takes a couple days for them to upload these things and get out there. So appreciate this kind of going out. It is the United States District of United States District Court, Central District of California, Gina Carano plaintiff versus Walt Disney Company, Lucasfilm, and Huckleberry Industries. This is the sub company that was over the Matrix. Or sorry, the Matrix, the Mandalorian, because this is all related to her casting on the Mandalorian. How did I say the Matrix? Oh my God. And this is case number 224 CV 101009 SPG SK. You can look up the case. It's in California. It's in federal court, but this is the district court. So this is, if you imagine courts, there's three levels. There's state courts, which have the basic court, right? The lowest level of court, whatever that level is in the state, they call it different stuff. Usually it's district court, but it can be called something else. You have the district court, the appellate court, and the Supreme Court, both at the state level and at the federal level. So this is at the district court level. Now, this is a motion, this is actually an order denying a motion for interlocutory appeal. So what they wanted to do was they wanted to get this sent up to the appellate court. They wanted to raise it one level to answer a legal issue, because in certain extreme circumstances, very extreme and extraordinary, you can go up to the appellate level to answer certain legal issues. However, it's extraordinarily rare, it's hardly ever granted, and it's hardly ever appropriate, right? Now, once the whole case has been decided, they can appeal. But here's where Disney needed to rely on this. They needed to rely on this because they don't want discovery. This is what I said from the beginning. Disney doesn't want their emails getting out there because they can get some serious corporate damage if their emails get out there and they say, yeah, we actively discriminate against white people. Yeah, we actively discriminate against people who are espousing Republican views, people that are not espousing the party line, that people that are going against what Joe Biden said or what the government narrative is, right? That will really hurt them as a company. Publicly, it will shame them. They've been hiding this fact. They've been denying this fact. The fact that would get out there would absolutely wreck them as a company. They would take a massive hit, right? It would be really, really bad for them, right? They might even face a shareholder lawsuit over it. I mean, there's a lot of stuff going on with that, right? Because they made statements that they don't do that they don't engage in that behavior, whereas we know that they actually do engage in that behavior. It's been very clear. So that's why it's interlocutory, right? They're now it's denying. So that tells you how this came out. We have a spoiler on how this came out. It was denied, meaning we have in the opening, we know that Gina won and Disney lost. And now one thing I will say is, and this is a very good thing to point out, I have always told you guys, Disney's number one superpower is not smart lawyers. It's lawyers that can tie you up in procedure. It's lawyers that will tie you up in court for years and you're going to run out of money. That's exactly what Disney's power is. And this is exactly what this was trying. Before the court is defendants Walt Disney Company, Lucasfilm, Huckleberry Industry. Huckleberry. I mean, when you bring in Huckleberry, you know it's going to, no, it doesn't sound good. And their motion to certify for interlocutory appeal and stay of proceedings. The court has read and considered the motion and concluded that it is suitable for decision without oral argument. Bro, Disney got beat so bad. This is how bad it was. Disney got beat so bad, they didn't even allow them to speak. Understand this. Usually, they will allow counsel the time to submit a brief, and which is a written statement of the law, a written argument, and also an oral argument. This was so bad, they didn't even give them oral argument. That's a shitty argument. That's a really shitty argument, which means they were just doing this for delay. They probably knew, even the lawyers probably knew this wasn't going to work. It's sad. It's so sad. Having considered the party submissions relevant law on the record, the court denies the motion. Plaintiff Gina Carano filed this lawsuit asserting various wrongful discharge and sex discrimination claims after defendants terminated her from the Disney Plus show The Mandalorian. Defendants moved to dismiss the complaint, contending the First Amendment barred her claims. Remember, my First Amendment! They lost on that. After considering both parties' briefing and oral arguments, the court issued an order denying their motion to dismiss, so defeating Disney's motion to dismiss, which was their best chance at winning. Defendants answered the complaint and filed an instant motion requesting they certify an order for interlocutory appeal and stay of the proceedings. The plaintiff timely opposed and defendants timely replied. So they oppose it and they reply. Disney's lawyers are getting paid so much fucking money for all this unnecessarily filings they throw out. It's ridiculous, right? As a general rule, the parties may not appeal a district court's rulings until after the court enters a final judgment. That is a general rule. So interlocutory appeals are special. They're only if, as they say here, pursuant to 28-1292B, they're only able to appeal if conditions specified in the section are met. And the district court certifies and the Court of Appeals exercises its discretion to take up review. Specifically, it needs to be one of these things to get an interlocutory appeal, to go up to the next level before they finish the case. Involve a controlling question of law as to which there's substantial ground for difference of opinion, and an immediate appeal may materially advance the ultimate termination of the litigation. Even if the three are satisfied, a district court still has the discretion in deciding whether or not to grant it. So even if all those things are true, they still could turn them down. And it has to be a legal issue, not a factual issue. Because the thing is, appellate courts don't answer factual issues. They answer legal issues. And at this point, by the way, we have barely any facts because we haven't gone to discovery. A district court should only grant it in exceptional circumstances in which allowing an interlocutory appeal would avoid protracted and expensive litigation. The party seeking certification has the burden. So Disney had the burden of proving this. An interlocutory appeal should not function to merely provide review of difficult rulings and hard cases. So it's more than just, oh, this is hard, or oh, this is a big case. It has to be a real, contentious, difficult question of law. Whether a First Amendment right of free speech protects an artistic entity's right to control its own casting decisions by declining to express its art through actors who made widely publicized statements that the entity deems offensive and harmful to its own artistic expression. This is complete bullshit. They tried to say that there's some big pending question of law about First Amendment rights of an artistic entity. First of all, they're not an artistic entity. They're a fucking business. They're a fucking business. To control its casting decisions. You mean fire and hire people? That's what the case is about, whether you wrongly fired her or not, right? So you're trying to reframe to control its casting decisions. You're reframing it. To fire somebody based on their political belief by declining to express its art. Oh, we're just artists. We're just expressive artists. Through actors who make widely publicized statements, Gina Carano, that it deems offensive, saying that COVID is going off the rails and expressing some opposition to that through memes. Through fucking memes. It's insane. Whether a court must defer at the pleading stage to an expressive entity's concern that associating its art with speech it deems offensive would impair its own expression. Whether an artistic entity has the right to consider an actor's off-the-job political speech when making casting decisions. Whether the First Amendment prohibits the use of state power to control private speech through equitable relief, but allows the use of state power to control private speech through monetary liability. And whether the First Amendment protections identified in cases like Green are applied differently in an employment context. Okay, so those were additional ones that the court gave them as a freebie. So they only needed to give them this one, but they considered all of this and they still said whether the defendant identifies a controlling issue of law. So the first question is this a issue of law that needs to be resolved by a higher court? A controlling question of law must be one of law, not fact, and its resolution must materially affect the outcome of litigation. A pure legal question is one whose answer is independent from the facts. So the law is something that is true regardless of whatever the facts are. Regardless. Period. End of story. It is the law. I am the law. Right? It's the judge dread. A party presents a controlling legal question when it alleges that a court articulated an incorrect legal standard. In contrast, where the question posed for appellate review would necessitate a detailed inquiry into the record, meaning if you need to look at any facts, it is likely a question of fact or a mixed question of fact and law. And we do not, we do not mix fact and law. We do not deal with the intermingling of fact and law. We keep them separate. Now, they're not equal. Law is more important than fact. There's a little bit of a two-tier system here, but we do not mix fact and law when it comes to interlocutory reviews. The question must be a pure question of law, that can be resolved quickly and without having to study the record. Routine applications of settled legal standards, the facts alleged in the complaint, are not proper for interlocutory review. Here, defendants contend, by virtue of having ruled on a motion to dismiss, the order necessarily raises a question of law. So they're saying because we lost our motion to dismiss, it's automatically a question of law. That doesn't even fucking make sense. That doesn't even make sense, to be honest. In opposition, plaintiffs argue that defendants, in fact, seek review of a question of fact, but not one of law. The court agrees here that defendants have failed to present a pure question of law suitable for review. So boom, they lose. What they're asking them to do, all these things, when they ask them these questions about the statements, about their artistic expression, you need to look at the fucking statement to determine whether or not this is even an issue. You need to look at the underlying statements. You need to look at the facts. We don't have those yet. We don't. So, as an initial matter, the invocation of Placid is misplaced. Placid arose on direct appeal. It was dismissed for lack of jurisdiction. So they're citing other cases. Defendants contend that ruling on a motion to dismiss necessarily concerns a controlling question of law. In fact, defendants' motion makes it clear the real issue is with how the court applied various precedents to the case in hand. In effect, defendants seek an opportunity to have the Ninth Circuit review whether the court concluded the defendant's affirmative defense was not impenetrable, as required to prevail on a motion to dismiss under Ninth Circuit law. So they're trying to get a second bite of the apple. Why are they trying to do that? They're trying to do that because the Ninth Circuit Court of Appeal is one of the most woke, biased, skewing far left courts out there in existence. The Federal Ninth Circuit Court of Appeals. They wanted to go to the wokest of the woke, the leftist left, the most biased circuit ever in existence in all of these United States, and try to get a favorable ruling from people that they thought would be in their court, because in this case, they're representing the left. And Gina represents the evil far right, even though, once again, Gina is never identified as even a Republican. She's not even really necessarily political. She had an individual opinion on an individual issue that didn't align with the woke narrative that Disney needed to be pushed forward, right? They were pushing for a specific narrative, particularly regarding the pandemic, right? And so they needed to go to that Ninth Circuit in order to get that favorable opinion. Let's continue. Whether defendant establishes substantial grounds for difference of opinion. Even if defendants have raised a controlling question or questions of law, however, they have failed to meet their burden to show substantial ground for difference of opinion. Courts generally find that a substantial ground for difference of opinion exists where the courts are in dispute on the question, and the Court of Appeals of the circuit has not spoken on the point. If complicated questions arise under foreign law, or if novel and difficult questions of first impression are presented, in contrast, that settled law might be applied differently does not establish substantial ground for difference of opinion. So saying that law could be applied differently by a different judge is not enough. Say that, oh, well, a different judge would have ruled a different way. That's not enough. That's not good enough. Sorry, not good enough. Similarly, a substantial ground for difference of opinion is not established by a party's strong disagreement with the court ruling. So, and this is what they had here. Disney was just butthurt that they didn't get a ruling in their favor. That's not enough. Here, defendants have not identified a circuit split on the proposed questions. That means they haven't found courts that have ruled differently. That's what a circuit split means. A circuit split means that there's differences of opinion with different courts. That hasn't been identified on these questions. These are novel questions. Instead, defendants argue that reasonable jurists could disagree about how these precedents apply to the case at hand. That literally is not the standard. And I think that the lawyers knew that when they filed this. I'm confident they knew that when they filed this. But under Ninth Circuit law, this argument is a paradigmatic example of a failure to establish a substantial ground for difference of opinion. Additionally, although defendants purport that to identify 4 critical aspects of the order's legal analysis, which reasonable jurists could allegedly disagree, this portion of the motion fails to accurately characterize the reasoning of either the order or the defendant's case law, let alone show substantial ground for difference of opinion. Bro, it means they aren't even accurately describing the real arguments. They're ignoring. Disney is not even making the right arguments. It's crazy. First, citing Green, defendants argue that reasonable jurists can conclude that the standard applies here, the deference standard applies to the entirety of the lawsuit, including the pleading stage. Defendants contend that this began as a motion to dismiss and was converted to summary judgment only on a limited issue of no relevance here. Defendants also assert the Ninth Circuit's ruling in Green was not based on a developed summary judgment record of undisputed facts. Defendants are wrong. So literally straight up saying, Disney is wrong. In Green, the district court converted the motion to dismiss into a motion of summary judgment so the parties could engage in limited discovery and submit supplemental briefing on a question of whether Miss USA is an expressive association and to evaluate the pageant's freedom of speech claim. The limited issue on which Green was converted to summary judgment was on the question of whether the defendant was an expressive association. Far from being of no relevance to the order, this question is essentially relevant. So saying in that case, it's much different than here. It's entirely different than here. In contrast, the order was not decided in such a posture, meaning this is a different case. Second, defendants contend the order held that the First Amendment does not confer on expressive entities the right to disclose with performers, right to disassociate with performers based on their off-the-job political speech. So the point is, Disney's trying to say, we want to be able to fire people based on what they say off the job, based on their political speech, which is at the core of the labor law. The labor law literally says you cannot do this. The labor law literally says California business entities cannot fire people for politics. And the reason why they did that was to prevent the evil conservative corporations from firing left-wing employees. But guess what? Here's how it backfired. Most major corporations are now left. And I imagine this law may be repealed because they're going to realize that in California, say, oh, wait, shit, this is working against our political side. So we're going to get rid of this law. Now, that won't change this lawsuit, right? Even if California scrambled. But I guarantee you they may change that law because they realize, oh, wait, all the big corporations are now actually really, really left aligned, especially California corporations. Any corporation that's still in California, headquartered a major corporation, is extraordinarily left aligned. It's the way it is. The court will not certify for appeal a straw man argument conjured up by defendants in an apparent attempt to create conflict between the order and the case law considered therein. They literally called Disney's argument a fucking straw man argument. These guys are getting bent over legally. Similarly, defendants mischaracterize a 3-sentence. They can't even get 3 sentences right. This judge is cooking Disney, is roasting Disney. Third and similar, they mischaracterize a 3-sentence passage in which the court reasoned that the First Amendment may place certain restrictions on the remedy plaintiff may seek for her claims. Defendants, Disney, contends this material suggests that the First Amendment protections against state interference with casting decisions depend on the remedy sought. So they're kind of saying, hey, the First Amendment protects us from the court. Oh, the court can't do anything because the First Amendment. Again, as stated by plaintiff, meaning Gina, as stated by Gina, Disney misses the point. The court did not, as Disney insinuated, reach the issue of what kind of liability would be imposed upon Disney if Gina were to prevail on some or all of her claims. Given the contours of Disney's motion to dismiss, such a determination would have been premature, and accordingly, the court did not make it. Because this conclusion is not contained within the order, the court will not certify the order for review. Owned. Finally, defendants argue, and by the way, guys, so we're going through this, right? So the court is denying them. They only had to deny them once for this not to go. The court is giving a multitude of reasons why Disney fails. This is an absolute whomp on the head, right? It is an absolute slap to their counsel, to their arguments, and it shows that they're just engaging in what is lawfare. Finally, they argue that reasonable judges could disagree with the order's effort to distinguish leading cases on the grounds they did not arise in the employment context. Again, Disney misunderstands the order. In their motion to dismiss briefing, Disney asserted 2 Supreme Court cases. And the court's correct observation that neither of the cases that Disney cited were employment cases. So Disney, like many of the other lawyers, Nick, were citing cases that weren't even employment, right? They're citing random other cases that had nothing to do with this, which imply that these cases arose from the employment context. Additionally, nowhere did the order articulate any premise that the First Amendment protections for expressive entities apply with less force, if at all, in the context of an employment lawsuit. Tellingly, defendants do not offer a citation to any portion of the order in support of this claim, nor could they because no such material exists. Holy fuck. They're literally saying that there's no proof they could have offered because it doesn't fucking exist and they're making it up. That Disney was completely making it up. In sum, defendants failed to show a substantial ground for difference of opinion. Additionally, the court will not certify for interlocutory appeal holdings not made in the order, right? Okay, going down here, whether an immediate appeal will materially advance termination of litigation. Finally, defendants failed to establish that the questions which they seek to certify would materially advance the ultimate termination of litigation. Defendants argue if the Ninth Circuit reverses, then the case is resolved. As the court previously explained in the order, however, defendants' narrow focus on the question of termination overlooks Gina's allegations concerning various conduct they engaged in before and after terminating Gina from The Mandalorian. Because this conduct lacks any obvious artistic or expressive quality, Disney's affirmative defense cannot be impenetrable. Plaintiff's lawsuit would move forward with discovery regardless of how the Ninth Circuit might decide the certified question. Look at this. So this is important. Gina would get discovery regardless. And this is what they're afraid of. The judge is pointing out that the exact thing that they're afraid of, she's going to get. Oh, she's going to get it, baby. We're getting that W. Consequently, the court's decision to deny the request to certify for interlocutory appeal is not only consistent with 1292, but also well-recognized obligation of the judicial branch to avoid deciding constitutional issues needlessly. In short, the salutary principle that the essential facts should be determined before passing upon grave constitutional questions is applicable here. Although defendants invoke Green for the proposition that it is important to resolve First Amendment cases at the earliest possible juncture, the Ninth Circuit in Green concluded that, in light of discovery, the trial ordered on expressive association, the court had a record sufficient to resolve the case on defendant's free speech claim. In contrast, in this case, the order makes abundantly clear that given the allegations, the court lacks the record sufficient to resolve the claim based on Disney's defense. We need discovery. Disney wants us to decide this with no proof. But guess what? We need proof. And Disney knows they're fucked if they have to give that proof. Disney also asserts that if the Ninth Circuit affirmed the order, it would protect Disney's constitutional interest in avoiding costly speech-chilling discovery proceedings. Defendants do not, however, explain how a Ninth Circuit opinion would alleviate the burden of responding to the discovery plaintiff has propounded to date. Nor is it apparent to the court how such a decision could provide such relief. I'll only apologize to you, nobody else. I'm not Asmongold. In any event, arguments regarding discovery, which the court notes were not an issue in the order, do not appear to have any bearing on the termination of litigation and do not persuade the court that certification is appropriate. Conclusion: for the foregoing reasons, the court denies defendant's motion. It is so ordered. October 15th, Honorable Sherry Lynn Peace Garnett, based. Bay Sherry, baby. Don't fuck with Sherry. Sherry just fucked you up, Disney. That was a killing. Guys, I've read a lot of motions. That's a slaughter. That is a slaughter. Disney got absolutely destroyed. And it's nuts because now we know we're going to get discovery. We know. The court said it. They're like, nothing's going to stop discovery here. So we're at a point where Disney needs to say, Gina, how much money do you want? We'll give it to you in bags. We'll give it to you in, gold bars. I don't think Gina would take stock because that's going to be plummeting.